Welcome to Talk+Water, the podcast that takes a deep dive into the world of water with those making waves. My name is Todd Votteler, and I'm your host for Talk+Water. I'm also the editor-in-chief of Texas+Water and the Texas Water Journal. You can sign up for Texas+Water by visiting Texas+Water.org, and you can sign up for the Texas Water Journal at TexasWaterJournal.org. Both publications are free. My guest today is Professor Abigail André, an environmental litigator with over a decade of experience enforcing the Clean Water Act. She recently joined the staff of the Vermont Law School's Environmental Advocacy Clinic after 10 years of environmental litigation with the U.S. Department of Justice's Environmental Enforcement Section. From 2010 to 2016, Professor André helped litigate cases arising from the 2010 Deepwater Horizon oil spill in the Gulf of Mexico, which led to the largest environmental civil settlement in U.S. history, and for which she received the Attorney General's Distinguished Service Award in 2016. Abby, welcome, and thank you for being part of Talk+Water.
Thanks for having me.
So let's start out with your background in water. How did you first become involved with water?
So it was 2010, and I was finishing up my law degree at Ohio State when the Deepwater Horizon oil rig exploded in the Gulf of Mexico. So if you remember, starting on April 20th, the nation was pretty much glued to the TV, right? There was footage of ongoing spills playing live in our auditorium, and I was watching it between classes and on breaks, and I'd wander down and just sit there, and day after day, nothing changed, nothing happened. So stepping back, I knew by then that I'd be joining DOJ in the fall, and I'd be working in the environmental enforcement section. Now, they do all of the civil litigation, most of the civil litigation arising from Clean Water Act, Oil Pollution Act, and other major statutes. So we were allowed to preference which area of the country we'd focus on. And by spring of that year, I hadn't chosen. And after sitting there and watching for days and then weeks, I preferenced work in the Gulf and was assigned ultimately to work in the Gulf. So I went to DC that fall, and after asking, an opportunity arose, and I was added to the team to litigate the case, and spent the next 6 years mostly down in New Orleans, in and out of the Eastern District of Louisiana, trying the case. And that's how I started working in water.
Wow, interesting. Yeah. Well, so my wife is from New Orleans, and so spent a lot of time there, and it's a really great place. Very interesting, very different, but we love it. And I'm sure I know the exact area where you were, where all the federal court buildings are located. I've been over there a number of times.
Yep.
Okay.
It's right there. It's not that far from the quarter, really.
So that's a really unique opportunity. I mean, you're in school, and then you're right in the middle of the biggest environmental litigation, I guess, in the country's history. I mean, is it close? Is that probably correct? Or
it ultimately was the largest environmental trial in our history, and certainly the largest that the DOJ had ever been a part of. It was 3 different trials for the U.S.'s part over 6 years in front of Judge Barbier down in the Eastern District. And it was an incredible and very unique experience to go from school into that case so quickly. I was very lucky.
I'll bet. Well, so one of the things that I wanted to talk to you about today, among several, is the U.S. Supreme Court. And how the court has changed over the last few years, because, there's, kind of a new lineup of Supreme Court justices, and what you think, that might mean for environmental law in the United States. And so why don't we kind of start off with that?
Yeah, well, it's a big question, and I think there's a lot that could change. So as you say, the Trump administration really radically altered the court with the help of Mitch McConnell. 3 new justices in the last 4 years, all of whom were specifically chosen for conservative views on a number of issues. And I should say, we often try and read tea leaves about how judges are going to rule before they're on the bench in this particular place. And it's not always fair. Sometimes we're wrong, but we do have some indication now about how the law may change. First, I think it's just important to recognize that Justices Kavanaugh and Roberts are now considered the swing votes. They're considered the middle of the courts. Whereas when Roberts was appointed, he was definitely viewed as more conservative. To his right, you have Justices Alito, Thomas, Gorsuch, and now Barrett, most likely. So to say there's been a dramatic change, you really can't overstate it. It's a huge change. So we know a few things about Justice Barrett. And we know she's an originalist, that she was a Scalia clerk.
So let me stop you there. Why don't you explain to us what an originalist is? Because not everybody will know that.
So there are a couple ways that judges look at the law and interpret the law before them. And generally, you call yourself a textualist, where you're really focused on the language of the law, and originalists fall into that category, or a purposivist, where you look at what the law means and you try to look not only at the language, but the congressional records and the history surrounding the law, why the law was made, to try and understand what Congress wanted the law to mean. Because despite best efforts, the laws that Congress write are not always crystal clear, right? So Barrett, in the originalist camp, tends to take a narrower view based on purely textual readings. And historically, her predecessor, Scalia, and others in the originalist camp in the Supreme Court have taken pretty narrow views of environmental statutes and environmental law. She's also signaled criticism for expansive application of the Commerce Clause, which is what allows Congress to really write these sweeping Clean Water Act, Clean Air Act laws, that there's some hook with interstate commerce, right? That it impacts more than one state, and therefore it's not solely a state issue. So she has, through her academic writing, tipped her hat about those two things, but she hasn't been on the bench for very long, and she doesn't have any major environmental rulings that we can look to for more information than that. So that's kind of Justice Barrett. I think we will see how she rules. I think, though, it's absolute certainty that she will rule on the conservative end of the spectrum. So from the perspective of NGOs who work on citizen suits, which allow people like you and I to bring cases under the big environmental statutes, I think the changes to the court are really going to fall into 2 categories. I think first, you can see attacks on the tools that environmental lawyers use to get to court, like standing. And then second, I think you'll see some attacks on the foundations of environmental law itself. So the constitutional bases that underlie our laws. And both will really have a narrowing impact on the Clean Water Act, but any major environmental statute.
So with standing, you're in access. I mean, essentially, that is who's affected by some action and can therefore file a lawsuit and pursue some remedy. Is that essentially it?
Yeah, that's essentially it. So standing it requires you to articulate a discrete, concrete injury. And how that injury is defined really determines how many people can bring claims. And you have two major precedents which have been kind of weighing against each other and balancing each other over the last couple of decades. One is Lujan, which Justice Scalia wrote for the majority, which said, if you don't have particularized injury, you can't bring cases that simply say, we don't like how the government is running this program as far as environmental harm goes, right? You can't just walk into court and say, I'm one of thousands of people that think that the government is doing a bad job here. It has to be more specific than that. On the other hand, Justice Ginsburg in Laidlaw said that environmental plaintiffs didn't need to show actual injury for standing, just a reasonable concern that injury may occur. Right? So you could look at pollution in the lake outside your house and worry that that impact might impact your health, your family's health, and that could be enough to get you to court. So here's the shift. The shift that we suspect we'll see now is a narrowing back of standing. In 2007, there was a landmark case decided called Massachusetts v. EPA. It was written by Justice Breyer and said that carbon dioxide and greenhouse gases were air pollutants under the Clean Air Act and could be regulated by the Environmental Protection Agency. So the justices that signed on were Breyer, Ginsburg, Kennedy, Sotomayor, and Souter, and Stevens. And with the exception of Breyer, they're not there anymore. In the dissent, Justice Roberts wrote that courts only have jurisdiction over cases where there's an injury that can be traced to a particular action that the courts have the power to redress, right? And so what people think might happen now is if there's another case like Massachusetts v. EPA that tries to get the court to expand to address something like climate change, for example, that what was a minority opinion in Mass v. EPA would become a majority opinion here. And the court will say, if we don't have a way to fix it, and if the injury can't be traced to a particular action, it could block access to courts. So it's a circuitous kind of path through all of these cases. But where we land now and why people are worried is that Roberts has foreshadowed what he would say if he were writing for the majority. And on climate change in particular, he said in that opinion that it would be pure conjecture to suppose that EPA regulation of new automobile emissions would aid in the loss of Massachusetts coastal land, which are the facts surrounding the case in the first instance, which suggests maybe he doesn't buy into climate change as a concern that he thinks courts should have much to do with. And we know that Barrett might agree with him on that front.
And that came from her confirmation hearing, I think, because she was asked about that, I believe.
That's right. Vice President-elect Kamala Harris actually asked her about climate change. She asked whether climate change was real, and Justice Barrett said she wouldn't answer the question because it's a contentious issue. And those of us in the environmental fields are upset to hear that opinion, given that we think it's a scientific certainty that climate change is real.
Gotcha.
It's only a matter of how we're going to deal with it.
Okay. So now kind of taking a look at some other things that the Supreme Court does, if you've listened to Talk+Water before, we've had some discussions about some of the cases over water between states, like Florida versus Georgia and Texas versus New Mexico and Mississippi versus Tennessee, for example. Do we have kind of any, clues as to what might happen in that type of litigation? Because, there's more of it, it seems like as we're moving forward, and I, was interviewed about Mississippi versus Tennessee here not too long ago, and I think what I said in the interview was that those issues are expanding from the Western U.S. to the Eastern U.S., although they wrote down shifting from the West to the East. Now we still have them in the West. And so to me, it seems like we're going to have more of those. And so I'm curious if you have any thoughts about what it might mean for that type of water litigation between the states.
Yeah, I think this one's very hard to say because attitudes of justices in interstate cases have traditionally been hard to predict based on ideology. And these are very traditional interstate disputes with a special master and equitable apportionment. And so I'm not sure that we can predict how conservative justices would look at the Army Corps perhaps preferencing Georgia's water rights over Florida's water rights, for example. But I think it's possible that a more conservative court will have less sympathy for states whose claim of injury are based on environmental harm versus economic harm or other things. So Florida v. Georgia is forefront in my mind in that case because the Apalachicola River has so suffered from low water. And the way that the state has presented it to the court is mostly environmental harm, even though there is economic harm wrapped up in it. So I think it's hard to call, but cynically speaking, it's possible that this court will have less sympathy for those states which are claiming purely environmental impacts. Yeah.
So it seems like to me that in the 80s and 90s, the Supreme Court was ruling on some major environmental law issues like every few years. And then, I don't know, I think I've been keeping up with events. I mean, it seems like the last 10 to 20 years, the pace of getting, major environmental law rulings from the Supreme Court has really kind of slowed down. It does really just, to me, it doesn't seem like there've been that many over the last couple of decades. And so I'm just curious am I just, misinformed or what's going on?
No, I don't think you're misinformed. I think a few things are probably happening. Most of these statutes were written in the 70s. Some of them have been amended since then. So in the 80s and early 90s, you saw a lot of testing of the edges of the statute. Congress's authority, EPA's authority, and a lot of cases about what the statutes meant and didn't mean. So much so that you have some cases that are kind of considered like settled law, right? And so you don't see big cases about what the Clean Air Act mean and the Clean Water Act means just because we've already done it. We've already tried it. So unless something were to change about the law, you wouldn't expect necessarily questions that seem as sweeping as those that you saw in the 80s and 90s. But we are seeing an uptick in how administrative law is practiced, which has a profound impact on environmental law. So, administrative law is just law of the agencies. It's how they write regulations to give life to the Clean Water Act and how they're enforced. And this year, even you did see in a couple of cases, Kaiser, Gundy were both big admin cases, not environmental matters necessarily Gundy certainly wasn't, but they will have trickle-down effects on how environmental law is written, how environmental law is enforced. Now, of course, also in the last 10 years at least, there's been a huge shift in the court. It's become more conservative, and particularly since Chief Justice Roberts arrived, environmental law cases that have come before the court have not all gone that well, 2009 went down as just the worst term for environmental law cases kind of in the history of environmental law. And so perhaps also NGOs are not choosing to bring as many traditional large-scale questions as they used to. Although I will say Maui County of Maui came out this year, and it was the first really big Clean Water Act case in a decade. And it was a huge win for water rights and, a progressive interpretation of the law.
So, to me, what you're talking about is the kind of the guts of how things are done. The agencies issue these rules that, as you said, tell everybody how the acts passed by Congress are going to be implemented and enforced. And so if that kind of law is changing, it would seem like, that's well, not only for environmental law, but everything, that's going to be significant.
Yeah, absolutely. And, one theory that people have been kicking around with the shift in the court is whether or not the court will revisit this concept of non-delegation. So non-delegation is a constitutional doctrine that says Congress basically can't give its power away. And in the administrative law setting, it says if Congress is going to give its power away, it has to give a certain amount of guidance and instruction and intelligible principle to the agencies about how the law is supposed to be enforced. And we have reason to believe that some of the more conservative justices might revisit non-delegation, even though it's been pretty settled and untouched for almost a century, to say, Congress, you're giving away too much of your power. If your laws aren't clearer, then you can't just let agencies write the law for you. They're not full of elected officials. They're not, it's outside the political process in their view. So there could be big impacts.
Okay. So see if I had this right. So what you're saying is that they might take a look at some acts and say, that's too general. You got to be specific about what you're telling the EPA they can do. Something like that?
Yeah,
okay.
Exactly that. So for about 100 years, when an agency's actions has been challenged as kind of off the reservation from what Congress intended them to do, they've looked at the statute, what Congress wrote, and looked for what's called an intelligible principle. It's basically an owner's manual, right? And it hasn't taken much to find it in these cases. They've basically given Congress the benefit of the doubt. It's been pretty permissive. But the court might start to make it tougher to identify an intelligible principle and say that if you can't find one, then Congress has violated the non-delegation doctrine and has given away too much of its power without enough guidance.
So, I've heard in the past all this discussion about the general welfare clause or something like that a lot of things kind of flow from that. So maybe not it's not very specific, right? But is that an example of something that, it doesn't really specifically say anything in the Constitution about, some specific issue. And maybe you can't really attribute it to general welfare or something.
Yeah, it's just so, because general welfare is a term that you see throughout environmental law, used throughout environmental law, that's not defined by Congress. And that happens a lot, that they use terms like waters of the U.S., but they don't tell us what it means. And so it's left to agencies to interpret it. The interpretation changes based on who's in the White House. And then courts have their own interpretations that get layered on top of it.
Right. And states have their own interpretations.
Exactly.
And I've had the enviable task a couple times of trying to mesh what the federal regulations said with what some states had. And, it's like, okay, this is like two different languages here. And it's hard to really find an intersection.
Yeah, it is.
Okay.
Well, and think about who are congressmen. They're not generally scientists with deep technical knowledge of, these things.
Right.
And so they send them off to the agencies to try and make it work. And it's important to have expertise at those agencies. Right. Congress is probably not up to the task to regulate with the same specificity that agencies do. But you're right. Trying to make sense of all the states' programs versus the federal programs can be pretty dizzying.
Yeah. Well, this is a conversation for another day, but I've been keenly interested in the report that the Congressional Research Service puts out every session of Congress that details how many folks in Congress are attorneys, how many are business owners, and then how many, might be scientists or something like that. And, the number of scientists, it's pretty small. I mean, or engineers even, there used to be a lot of engineers, but, in Congress, but not so much anymore.
Not so much anymore. And frankly, that's why we have agencies, so that Congress can say we have this huge country, and in the area of environmental law, we have pollution, which doesn't stop conveniently at the border of Montana before it passes into another state.
Right.
So we need experts helping Congress to figure out how to tackle these big problems.
Even though it'd be nice to have a few more scientists and engineers in Congress, but
I think it would be.
So,
I mean,
couldn't hurt. Kind of shifting topics here. So now we've got the results from the 2020 election, or most of them, enough to say that we have President-elect Biden and Vice President-elect Harris beginning their terms sometime in January, I guess the 20th maybe. And so I'm interested what you think the implications of the new administration coming in might be for environmental law at the Department of Justice.
Yeah. So President Trump, there are a lot of norms about how the Department of Justice is supposed to run. They're not written down as laws anywhere, but there are a lot of norms that help the DOJ be independent from the White House. And the Trump administration was involved in environmental law in particular in a way that was pretty unprecedented, not only at the agencies, but for the DOJ as well. There was a lot of political involvement in how we brought cases, whether we brought cases. And I can't speak for all of my colleagues, of course, and what their experiences were, but it seemed greater than kind of the natural policy shifts that happen between administrations, and necessarily so, right? When the parties change, there's a mandate, and the DOJ's work necessarily changes in response to it. So given that as a predicate, that the last 4 years has been very unusual for the DOJ and the rest of the executive branch, under Biden, I suspect there will be a greater than usual course correction to come back to where we were under President Obama, and hopefully expand even further into some protectionist policies. For the DOJ, that means that career attorneys will likely have more freedom to argue and file cases based on expansive arguments. But again, it depends a lot on who's in charge at the DOJ and how involved they choose to be in the work of career attorneys.
Gotcha. So, you just mentioned the Trump administration, and, they had a goal over these last 4 years of repealing 100 environmental provisions or programs. And so I'm interested in how close, did they get to attaining their goal? And what do you think that effort or what happened to that under the Biden administration? In other words, can it all be undone? Or are, we kind of in a position where we're just going to have to live with the 100 or close to 100, I guess, that were repealed or eliminated or something?
Yeah. So the rollbacks have been unprecedented. The Sabin Center at Columbia, which is focused specifically on climate change, so it's a bit more expansive a list, but I looked yesterday and they'd counted 159 cutbacks on environmental protection or promotions of fossil fuel or both. And the regulatory rollbacks are across the EPA, DOI, many agencies that deal with environmental policies, right? So can it be undone? It depends. It depends on how it was done in the first place. Biden has already said that he will immediately issue a number of executive orders to reverse things that President Trump did through executive order. And that's relatively simple. So that will happen, I imagine, the first day he is in office.
So that's a repeal, essentially. We're going to go back to
another executive order that basically overrides Trump's executive order. But then other discretionary actions, so things that aren't regulations, like permitting of the Keystone Pipeline, can be undone. And President-elect Biden has said he's going to undo them as soon as he's in office. Internationally, he can re-enter the Paris Agreement right away and try to start getting the United States back at the table on that front. And I think most importantly, and which people should be very excited about, is Biden can immediately stop the war on science that's been present under the Trump administration. And by hiring scientists with excellent credentials and kind of repopulating the agencies with experts that were lost either through attrition or other means during the Trump administration. Where it gets tricky is reversing final agency regulations. So when the Trump administration has gone through actually the administrative process of notice and comment and rulemaking, and they've created new law. So Biden can't just come in and say, none of that. They have to answer it with another rulemaking, with another proposed legislation, regulation. And there are stumbling blocks for that. They have to have reasoned explanations for undoing Trump-era final rules, and it will keep the agency very busy, and these processes could take years. So examples of those are the Waters of the U.S. rule, the methane rule, changes to car emissions. There are things that will take President Biden longer to do unless there's language in the regulation which allows for a more permissive interpretation, where Biden can tell his folks at the agency to interpret it and apply it in a different way than the Trump administration did while they go about rewriting it.
So that's the thing that I've been thinking a lot about, and I'm glad that you mentioned this, because I want to drill down on this point. So, so it sounds like it's possible for the new administration to, take a look at, some provision of some act passed by Congress for which the Trump administration, repealed or changed a provision, and say, okay, well, we want new rulemaking to counter that. And by the way, our interpretation is, hey, this does more than the original rulemaking. I mean, so you could get actually some expansion of protections for air, water, land, wildlife, etc. That probably weren't really that probably wasn't really anticipated when this repeal process started. That it might ultimately kind of result in a kind of a boomerang kind of thing for some of this.
I think that's right. I think there will be a pendulum swing back to where the rules survive, notice and comment, and litigation that might come after it, back to not only the Obama era, but then even more protectionist beyond that, particularly in the area of climate change and air pollution. I think you'll see that.
Okay, interesting. So, everybody has to, stay tuned for that. Because those will be, I guess, processes where there's going to be a publication in the Federal Register, and people will be invited to comment on whatever rule that's being developed by whatever agency, and so there'll be public participation in that process, and so I imagine a lot of people will be engaged in that.
Yeah, and I think you'll also see litigation from industry arising from some of that. There's law surrounding when an agency changes its mind and how it does that, and what kind of justifications it has to provide. So I think you'll see not only robust public comment, but also probably some cases cropping up, just brought by industry rather than NGOs, more likely.
Well, that brings us back to the Supreme Court again, I guess. The importance of the makeup of it is, that might be felt there when those cases, or if those cases make it to that level.
Mm-hmm. I think that's right. I think particularly, President-elect Biden has a $2 trillion climate change plan. Now, if the Senate doesn't go Democratic, it's unlikely he'll get all the money for that. But what you will see is a lot of regulation to try to combat the impacts of global warming. And I think there is reason for concern when those regulations land in front of the Supreme Court as it currently sits.
Okay. Well, let's go ahead and end with a question about your work at the University of Denver's Sturm College of Law and the Vermont Law School's Environmental Advocacy Clinic. Is it Sturm? Did I say that right?
It's Sturm. Yeah.
Sturm?
S-T-U-R-M.
Okay. So what are your impressions of the new crop of environmental attorneys that you're training? What do you think motivates them? Any differences kind of stand out from how you remember, being a student at the Moritz College of Law at Ohio State, and getting ready to go down to New Orleans to get involved with the big oil spill case. What do you see in the new group?
Well, the new students are incredibly social justice oriented, climate justice oriented, and are focused on environmental law in a pretty cutting edge way that I certainly didn't get when I was in law school. I had excellent professors, but, I was in law school during the 2008 financial crisis, and we were all pretty much just focused on getting jobs. Right. And I think the Trump administration and the Black Lives Matter movement this year, and COVID, it feels like we're at a tipping point societally, globally, and students are responding to that. They're very interested in how they can make a difference in perhaps more unusual environmental advocacy ways, not just being a litigator, but how do you advocate for communities who are underrepresented and haven't historically had a voice in court? How do you help empower historically disadvantaged people to get clean water and get clean air and help them be the driving force behind the law? And that's a major shift and a necessary one that's reflective of our time and hopefully the direction we'll be going in. So they're very creative, they're passionate and committed, and really an inspiration. I think the students graduating from Vermont Law School are learning how to use the law to confront major challenges of the 21st century and make the world a better place. And I'm proud to teach them.
Well, one of my close friends got his LLM from the Vermont Law School, and he's from Alabama. And I remember him telling me about how great the trout fishing was. And so that's what that's always like a big impression for me. If I could go someplace, law school, and do some trout fishing, that'd be pretty great. But I imagine they're pretty busy. They probably don't have a whole lot of time for that.
Well, it is in a beautiful setting. South Royalton, Vermont is just a gorgeous place. And the fishing is second to none up here. So I do think when they get to take breaks from their studies, they're in a pretty beautiful environment.
That's great. That's great. So Abby, how can our listeners find out more about the Vermont Law School's Environmental Advocacy Clinic?
So we're just online at vermontlaw.edu. And, the Environmental Advocacy Clinic brings cutting edge litigation across the country on behalf of underserved communities. And we are doing a lot of really important work that I hope we get to keep doing. And if you are looking at law school and you want to be an environmental lawyer and litigator, our clinic is a great place to come and learn.
Great. Abby, I really enjoyed talking with you today.
Me too. Thank you so much.
Thank you. So this has been Talk+Water. My guest today was Professor Abigail André, a former environmental litigator for the U.S. Department of Justice's Environmental Enforcement Section, who is now part of the Vermont Law School's Environmental Advocacy Clinic. If you enjoyed this episode of Talk+Water, why not give it a like? Would it hurt you? I mean, I'm just saying. My name's Todd Votteler. Let's talk water again soon.